All right, we are going to get started. Just as a reminder, this is our Lawful Access webinar, and I'm going to kick things over to Graham.
All right, thanks, Alex. Well, I'm so glad you guys were able to join us, and because I think this is going to be useful for folks to understand kind of how lawful access intersects with their lives and with their businesses. So I'm Graham Dufault. I am Director of Public Policy here at ACT, the App Association.
And I'm Amy Richardson, and I am a lawyer and partner at Harris, Wiltshire, and Grannis, which is a law firm.
And so with this presentation, I wanted to cover two main topics. First, just give you some overview of when and how law enforcement can access electronic communications, and give you a little bit of background on how we got to where we are today, the state of the law. And then Amy will give an overview of how to respond to those requests that you get under the federal law. And so first, I would just like to describe kind of the scope of what we're talking about. The main law that we're going to talk about, we'll talk about a little bit beyond that, is the Stored Communications Act. And the Stored Communications Act governs when and how law enforcement investigators can access electronic communications content that's stored remotely. And so what that doesn't include is the body of law that governs when and how law enforcement investigators can access a communication that you yourself sent. So if the communication at issue is stored by the person sending the communication or receiving the communication, that's a different set of laws than the laws that we're going to be talking about here. So imagine the email service provider. What is their obligation, and what are they not allowed to do, conversely, when law enforcement contacts them for a copy of a communication that they're storing on somebody else's behalf, really. And so that is the Stored Communications Act. And it really is an outgrowth of Fourth Amendment law, and as most of us know, the Fourth Amendment protects us against unreasonable searches and seizures. And so the Stored Communications Act was enacted against sort of a backdrop of two main Supreme Court cases around the Fourth Amendment: Katz versus United States and Berger versus New York. And those two cases kind of define the outer edges of the Fourth Amendment's reach, as the Supreme Court defined it. In Katz versus United States, it was determined that Fourth Amendment protections apply to areas where there is, quote, a reasonable expectation of privacy. In that case, it was a public phone booth where a guy was having a conversation with somebody else, and the FBI was recording that conversation from the phone booth itself. And so the court found that the phone booth, even though it was public property, was a space where the person having the conversation had an expectation of privacy. And then in Berger versus New York, at issue there was a situation where the FBI was bugging somebody's office. And the Supreme Court determined that when the FBI, under a state statute, sought to record that conversation, well, the Fourth Amendment actually applies to conversations. So where there's even an oral conversation, there is a reasonable expectation of privacy, and that kind of was the outer limit there. But fast forward to, and again, these were 1967 cases, fast forward to the 1980s when computers started to hit the market, people started dealing with electronic data. It became pretty quickly realized that we didn't really know whether Fourth Amendment applied to electronic communications that were stored on a computer. And so Congress, trying to have some foresight, enacted the Stored Communications Act in 1986. to prevent, in the Senate Judiciary Committee's words, to prevent legal confusion, mostly, but also to ensure privacy rights, and to ensure that Fourth Amendment style protections do attach to electronic communications. I would describe the Stored Communications Act as primarily a blocking statute. So the first provision of the Stored Communications Act is that you're not allowed to disclose communications that you store on behalf of somebody else to third parties. But there are some very important exceptions, and the one we'll talk about today is the exception allowing government agencies to request data from you as a communications provider in your capacity as a facilitator of communications between two parties. And we'll flip ahead here. So the current status and the debate around the Stored Communications Act is really interesting, and there are two main features, I think, of the debate around the current law. The first is the due process requirements under the Stored Communications Act, and the second is the applicability of the SCA to data that's stored overseas. And so under the first issue, that is due process, older communications can be obtained using a subpoena. That is, if a communication, such as a text message, an email, whatever the content is 180 days old or older, that is 6 months old or older, and is in storage there with the communications provider, law enforcement really only needs a subpoena to gain access to that communications content. A lot of people don't know this, and if a communication is stored for less than 180 days, it requires a warrant, and a warrant, this distinction is really important. A warrant requires an independent third party, a judge or a magistrate, to find probable cause that gaining access to the information that the investigators seek is going to show evidence that a crime has been committed. So this is a really important distinction between a warrant and a subpoena. And so the Stored Communications Act does treat older communications as if they don't have as much of a privacy expectation. There is a sort of an exception here in the Sixth Circuit, which is Ohio, Kentucky, Tennessee, and Michigan. In a case called United States versus Warshak, the Sixth Circuit found that Fourth Amendment protections do apply to communications that are over 180 days old, and as a result, do require a warrant rather than a subpoena. And so even though the Stored Communications Act does allow for a subpoena for those communications, I will say that in that case, the court did allow the FBI to have that evidence entered that they saw it using a subpoena because they relied on the statute. They relied on the Stored Communications Act, which does allow a subpoena for older communications like that. So it is an interesting feature of the debate here, and it is the state of the law that older communications are treated with much less due process protection. And then the second feature is the applicability to data that's stored overseas. Up until spring of 2018, very recently, it was totally unclear, and the Stored Communications Act was actually completely silent as to whether or not it gave U.S. investigators the authority to seek communications data stored overseas by a U.S. provider. And so this is important because if the Stored Communications Act does not cover information stored overseas, then U.S. investigators have to go through mutual legal assistance treaties. Those are called MLATs for short. And under the MLATs, U.S. investigators have to issue a request to a foreign investigative body to conduct the investigation on the U.S. agency's behalf. You can imagine that that is a very bureaucratic process. It really is. A lot of really archaic requirements go along with it, and the average time it takes to get information back from one of those requests is about 9 months, unfortunately. And so it really matters whether U.S. investigators can access that information that's stored overseas. And so because of that bureaucratic process, the problem that you have when you cross borders and you have cross-border investigation, the Congress passed the Cloud Act, which updates the Stored Communications Act. So at the time the Cloud Act was enacted in March of 2018, this year, a couple of months ago, there was an ongoing Supreme Court case called Microsoft versus United States involving data stored in Ireland. And in that case, the Second Circuit had found for Microsoft and basically found that the FBI had no jurisdiction beyond U.S. boundaries, which is somewhat problematic in today's world where data really is global and storage often happens across national borders for efficiency reasons and other reasons. And so when the Cloud Act was enacted, it was after oral arguments in that case, but before it was finally decided. So the case was actually mooted, and under the Cloud Act, and the Stored Communications Act now says that U.S. investigators have jurisdiction, quote, regardless of whether data is stored within or outside the United States. And so it couldn't be much more clear than that U.S. investigators, so long as they're seeking information from a U.S. Communications provider, can seek communications content, communications information from under the Stored Communications Act. And they don't have to go through an MLAT. They don't have to go through a mutual legal assistance treaty to seek that information. The other thing the Cloud Act does, though, is that it authorizes the U.S. government to enter bilateral, that is, one-on-one comity agreements with foreign governments. And the purpose of those agreements is to enable foreign governments to investigate their own citizens when their own citizens are being accused of a crime in the foreign country. It just so happens that a U.S. communication provider is storing the communications of those targets of the investigation. It creates an exception from that blanket blocking statute just for countries that enter into the comity agreements with the U.S. But I will say that we do not have agreements yet. Again, the Cloud Act was only passed a couple of months ago. And so it's going to be a couple-year, at least, process for the U.S. to enter these bilateral agreements. There are some who say that we're going to enter an agreement with the EU itself. There are some who think that we have to enter agreements into each one of the EU countries, plus all the others. In any case, hopefully they'll fall into place quickly once the first one does. But in the meantime, before we sign those agreements, the blocking statute still applies, and you're foreclosed from responding to investigative requests from foreign governments. And so the only investigative bodies that you'll be responding to are U.S. investigators. So that rounds it out for the background and the overview, and I'll hand it off to Amy.
Thanks so much. And so we're going to build on that background and kind of overview and turn now to, like, if you as a company actually get a request for information regarding your client, one of your customers, under the Stored Communications Act, some real practical kind of stuff and tips. And where I'd like to start is some real basic, like what a request might actually look like and what to do immediately after you get it. So let's start at the beginning. What types of requests and what would it look like? Let's start with what would it look like. It's going to be a piece of paper. I think that's important. It won't be an email. It won't be someone coming in orally asking for it. It will be an actual thing. Graham talked about this being a warrant or a subpoena. So it's going to require a piece of paper. And those pieces of paper can look a little bit different ways. So the first way it could look like is what a warrant would be, or some type of civil investigative demand, which would actually reference the statute. So we've talked about the Stored Communications Act. These are the actual numbers in the code that refer to the Stored Communications Act. And people oftentimes shortcut it to section 2702 or 2703. So don't get wrapped up in the numbers, but know to look for, in whatever piece of paper you get, those numbers that clues you into this is the blocking statute that Graham is talking about, and this is likely an exception to it because it's a warrant or a subpoena. If it is a subpoena, it may not have those on it. Instead, it would have a case on the top. And the case would basically say this person versus this person. It might say the United States government versus a certain person. But the format might be a little bit different, but it is the same thing, right? So you're going to take that piece of paper, and the immediate thing that you want to do is, first of all, review it in detail to figure out exactly what the government agency or person is requesting, right? What are they asking for from your company? What type of information, how much of it, a specific customer, understand that. And then internally, before you do anything, get ready for a discussion with a government representative or agent, which is where we're going to go, about two things. Number one, what are they actually asking for, getting your hands around? How big is it? Is it for one customer and it's a little bit of information, or is it for a ton, or for one customer but it's a terabyte of information? Get your arms around that. And then also what your company's role is in holding that data, how you do it, how expensive it will be, all those kind of things. So those are the immediate things you want to do when you get a request for information under the Stored Communications Act. So the next thing that you want to do after you've gotten your arms around your piece of paper, figured out internally what it means to you, what they're asking for, is to actually contact the agency or person who sent you the piece of paper. Again, how do you figure that out? It'll be on the piece of paper. It'll be signed by someone. It will have an identifying agency. It might likely come with a cover letter that says, please contact me about it. There will be a way for you to get in touch with someone, and there also will probably be a date on it. So you want to reach out to the agency or agent, depending on how it works, and number one, just say, hey, I got this from you. Just want to make sure you send it to the right person, which seems like a silly thing to say, but remember, oftentimes the government is investigating. They don't have all of the facts yet, and they think that you have this information. You may not actually have the right information, or they might have gotten the company name off by just a little bit. So just say, this is who I am. You sent this to me. I now have it. And the next thing you would do is kind of use as an opportunity not only to find out what the agency is asking for, but how they view your company. Do they view your company just as the person that's got the information, you don't know anything about it, and that you can send it to them? That's great. But if there is something else, you want to know about that and understand. And you want to discuss with them what they think your obligations are, and what you have to do to satisfy their request. And that's why you want to kind of pregame this a little bit, which is understanding what you can have. So you can say to the agent, you've asked for this huge section of data. We actually don't have that. What we actually have is data from this date to this date. Or so you can let them know and make sure that it satisfies their request if you send that. You also want to make sure that they understand the kind of burden on your company to produce this information, and use that if necessary to narrow down the scope of what they're asking for. If they've asked for something that is a huge volume or costs a ton of money because you got to pull it out of some weird storage somewhere that you never thought you'd have to pull it out of, and it's going to cost your company, $1 million to do it, and that is a significant number. I think that's a significant number to anybody, but in particular to the size and scope of your company, you want to make that clear with the investigator, because you have the opportunity to narrow that based on the volume and scope. And really, they're just trying to get specific information, and you can work with them on that. Okay, so we've talked a little about practical. You got your piece of paper. You figured out what they're asking you. You're reaching out to someone. The next thing you want to think about is the actual kind of what are you obligated to do and what can you do. So let's start with the obligations. Graham gave you guys a great cheat sheet in some ways in his third slide, where he breaks down, the statutes or the law, the current state of the law and the debate. The current state of the law really gives you, where you got to look at it in the statutes, of like what you have to do. And when I mean what you have to do, the statutory requirements that we've told you, right? You're not supposed to give stuff unless it meets these exceptions, which are you've gotten a warrant or a subpoena. So based on that, you know the law and what you have to do, and you're going to turn back to the paper, right? Then the next question is not only what do you have to do, but what can you do? And that really points to any terms and conditions you've entered into or other contracts with your customer or client whose data is being requested, right? So when they initially signed up for this, you probably entered into a contract with them or they adopted terms and conditions. And you need to look and see under those terms and conditions, what have you promised your client or customer that you will or will not do with that information, right? And you want to make sure you're reviewing the terms and conditions specifically for when they signed up. if there have been any changes, make sure there have been any updates, if they've been properly put in place. Know your playing field, right? And try and determine, okay, based on that, have I promised something different or the same of what I'm obligated to do, right? Because if you're obligated to do something by statute, you should do it. If you've said in your terms and conditions you would not do it, you're suddenly caught between a little bit of a rock and a hard place, which is your statutory obligations to the government, always important, but also your contractual obligations to your client. So if you're listening right now, this is a really good opportunity to address this before it happens by looking at your current terms and conditions and making sure they're designed so you don't put yourself between that rock and that hard place. Update them if they're necessary to say, okay, this is how we're going to do this, customer. And you can always get their consent ahead of time to turn over information in response to a law enforcement inquiry. And in fact, you can incorporate the specific numbers of the statutes that I gave you a few pages ago to say, we're going to follow the terms of these statutes and any updates to these statutes as required, and you give us consent to do that. It makes it clean. It makes you out of that kind of rock and a hard place and kind of goes to your obligation of what you have to do and what you can do. So the next step that you have to look at is a little bit outside the Stored Communications Act, but important to stored communications, which is depending on what business you're in, what you do for your customers, you should also take a quick look to see if there are any other privacy laws or regulations that are applicable to you or your customer. A good example is, for example, if you have any type of healthcare information, you're probably very aware of all those type of privacy and other obligations are on that, but you want to make sure that with the data request, you're not also running afoul of another area like privacy or healthcare. Another good example is if you are holding any type of telecommunications information and you've got DP&I information. So anything that's protected, just double check both the data that's being requested, what can apply to that, and then your role as a company, right? If you're still in a certain role, they may not apply to you or they may, and you just want to be aware of those depending on the facts in your role. The other thing you want to look at is in your terms and conditions, which I've said a lot, but is important, is whether or not you've obligated yourself to tell the customer that you've gotten this request and that you've complied with it. I would encourage you to craft them that you don't have to do that because, frankly, when things are going on, you may just forget. And you get everything else totally right, and you forgot to give some type of notice, and then you're in breach of your terms and conditions. But look carefully at that. I also think this is a little bit of a business decision because you're walking a line here between making your customers know that you're trying to protect them, right, and store their information in the right way, but at the same time meeting your obligations. So you want to make sure if providing notice is something that helps you with your customers, make sure that's built into the process so you don't forget about it and don't do it if it's necessary to include. And the last thing to really think about when you kind of outside the Stored Communications Act obligations is what kind of information you're actually storing, right? Depending on your business, you could have stuff that as a legal matter is privileged, right? There's attorney-client communications, or there's some other type of privacy information that if you knew what was inside of it, you could create an obligation for your company not to turn it over. So you kind of want to make sure you actually don't know what's in there, because without knowing, you don't take on that obligation, or if you do, you need to make sure in your terms and conditions or somehow with your customers that you're not going to take on that obligation to protect that information, which is their information, their privilege, their privacy issues to deal with, not yours. So overall, that kind of gives you an insight into the practical aspects of what to do kind of from the very beginning of getting the paper and then all the way through and the things to consider till you turn it over to whoever has asked for the information under the Stored Communications Act. All right. Go ahead.
So we got a few questions in advance that I thought we would start with, and then we can open it up for any additional questions from folks on the phone. So I wanted to start with Graham. So Graham, you mentioned the use of bilateral agreements that are going to come with the Cloud Act. Do we have any bilateral agreements as of yet?
That's a good question. So we don't have any that are in effect. There is one agreement that we have already drafted with the UK. So the ink has dried on that agreement, but under the Cloud Act, it has to go through a pretty long process with a bunch of checks, not least of which is Congress has to sign off. So Congress has to consider it for, I think it's 180 days, and then they have to decide whether they will approve or disapprove of the agreement itself. The other thing that stands in the way is that the bilateral agreements do require a number of due process protections be in place on the part of our dance partner, the other foreign government that we're going to be signing these bilateral agreements with. It'll take a while for a number of countries that we're looking at to enter these agreements to update their laws to fit those requirements. So in my view, I don't think we will see the first agreement, that is the U.S.-UK agreement, for another couple of years, maybe a year at least. And then hopefully the rest will fall into place pretty quickly after that.
And what do we expect to see in bilateral agreements?
Well, under the Cloud Act, as I mentioned, it does impose some requirements on other countries to have due process protections in place. The other couple of things these agreements must have in them is there's a prohibition on those foreign governments that are going to be entering the signatory countries from targeting U.S. persons in investigations. So really the agreements are to enable the foreign governments to investigate their own citizens wherever their data might be stored. And it also requires foreign governments and enact in our law a process by which the target of the company that is being sought information from can challenge the request for information as either being in conflict with another law or for similar reasons. So it really does enable the company that received the request to say, hey, look, actually this request still conflicts with another law, even though there's a bilateral agreement in place. And so that's kind of what they look like.
That's helpful. Thank you. And Amy, practical question.
Yeah.
So the first of which is, you said we're probably not going to see one of these requests for data come through an email, but how are we going to see it? It's a piece of paper, but how do we get it, and where do we find it?
Yeah, so that is a real practical question and important, right? Because, to figure out if you got something, you got to get it. So two things to think about that. It has to be served on you, regardless if it's a warrant or a subpoena. It has to come to you in a certain way. And it can come in a variety of ways. Someone can show up and give it to you. But they absolutely have to provide that service. And a lot of times with government agents, that means they look at your service agent, which if you registered as an LLC or a corporation in your state, you put someone down who was your agent or service agent, who people could deliver things to so that service was proper. So go back and look and see who that person was, what that address was, make sure it's up to date, because that's where it's going to come to. And as soon as it comes to that place or person, the clock will start running, right? Because usually you have 30 days or something like that to respond. Don't worry, you can negotiate more time. But to negotiate for more time, you have to have it and know that you're doing it. So as a practical matter, look at your filing for your articles of incorporation or what you did to start your LLC or your corporation. Figure out who that person is, and that's who it'll come.
And you mentioned terms of service and that everyone should be reviewing their terms and conditions. And you sort of mentioned that it might be good to include some information about specific statutes that you think you might have to comply with or something along those lines. Where can they go to find that information?
Yeah, and I think the best place to start, you can find and start with the statutes that are actually in our slides. And we give you the numbers. And frankly, you can use a search engine, Google, Bing, whatever you're into, to find the actual statute, to look at it. When I'm making the recommendation, I'm actually recommending putting the numbers of the statute in your terms and conditions. So if it changes in the future, you don't have to update your terms and conditions. They'll automatically update because you've just referenced the statute. And as we all know, when dealing with terms and conditions, updating them is a real pain. So you want to design your terms and conditions that if the law changes, it kind of automatically changes along with your terms and conditions. The only exception would be if somehow Congress changed the number to the statute,
which frankly is something that doesn't happen very often. So that's how I'd recommend a nice combination of Google and using actual references to the statute.
That's great. So I thought we would open it up to the phone if anybody would like to ask a question.
Hi, this is Mike. My question is about essentially data retention. Let's say when people close their account, you delete their information within a certain number of days, and you get a request, and it happens to be somebody who recently closed their account or whatever. And so two things. Number one, what if you don't see that or notice it, and then you basically just deleted information that was requested by law enforcement? Are you in trouble because you're destroying evidence? And then if you do, and you have to, is the request always about past information, or can it be about future information? And can it mean that you essentially have to change your data retention policies in order to be able to comply with law enforcement requests?
I think those are all good questions. I'm going to try and start kind of at the beginning, and you let me know which ones I missed. So let's start with kind of, is it always past or forward-looking? Under the Stored Communications Act, it's usually past, right? If they wanted to do something forward-looking instead, they would have to do something that's similar to a wiretap, right, which is like a bug or something like that, and then they'd have to take possession of however the data is coming in, however the stream is coming in. So that's a little bit more complicated procedure, and the agencies would be different. It wouldn't be under this act, and it would be very clear to you, right? This is forward-looking, and there's like an FBI agent in your office. So this is really backwards-looking. And if your terms and conditions are clear about data storage, right, that you delete stuff after 7 days, right, which I know is a very short period of time. I'm kind of over-exaggerating to make it clear. If you've done that and law enforcement comes back and wants that information, you just have to say, I'm sorry, we don't have it. Here's our terms and conditions. This is our normal course of practice. I think you might be asking, like, you get the subpoena on a Thursday, it didn't quite come to you. You accidentally erase on a Friday. Like, what's going to happen? I think you have to just call law enforcement and be very clear. This is what accidentally happened. We got the subpoena on a Thursday. We didn't read it till Monday. We deleted in normal course on Friday. But I think this ties into the idea of, like, making sure you know who is getting served and when you get stuff. So you hopefully don't put yourself in that type of position, right? Because you haven't intentionally destroyed law enforcement records. That's what you want to avoid, is that you have a really great client. I know you would never do this, but you have a really great client, and they say, hey, can you make an exception to your terms and services and delete this stuff? And you think, well, that's weird, but I'll do it. And then you find out that the subpoena was sitting in your mailbox. Then it looks hard for you to have had an innocent intent, if that makes sense.
Yeah,
how did I do, Mike? Did I cover most of them?
I think so. Thank you so much.
You're welcome. Thanks for the question.
All right. If there are no more questions, then we will go ahead and end the recording. But I want to thank Amy and Graham for talking us through all of this. Thank you, Mike, for your question. Thanks to the folks who sent us some questions in advance. And if you guys need any more information, please head to our website. That's actonline.org. And we will also be posting this webinar in a few places if you need to follow up and listen to it again, because I think we got some really great and helpful advice. So thanks, everyone.